Good afternoon. My name is Austin Kilgore, and this is my portion of presentation for our group project on unethical behavior of educators. I worked with Davita Brown and Dr. Kimberly Warfield on this assignment, and it's been a pleasure working with them. Jumping into our table of contents here, we have 7 main issues that we addressed in this group project collaboratively. Issues concerning religion in public schools, freedom of expression for students, search and seizure, due process, liability and student records, individuals with disabilities, and the Alabama Educator Code of Ethics. I was tasked with issues concerning religion in public schools, due process and liability and student records. So those are the slides I will jump into right now. All right, first topic we will be discussing today is issues concerning religion in public schools. The first thing that I would like to think of that people should be mindful of is the First Amendment, okay? And that amendment states, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the rights of the people peacefully to assemble and to petition the government for a redress of grievances. Okay, educators and students are protected by the First Amendment, so it's a two-way street. This prevents the government from establishing religion and protects privately initiated religious expressions and activities from government interference. Students must lead religious activities to be protected under the First Amendment. So if you are having any student activities, so student courses in your school that are based on religion, it has to be student-led when you do those, and it has to be initiated by students as well. All right, the next thing I would like to discuss addressing in this topic is the Establishment Clause. Okay, and this states that no government can disengage a religion from the official state religion, and no government can force to engage in religious exercises or to profess religious beliefs. Okay, we know that we are government employees, so we fall under the Establishment Clause. Once again, government cannot establish a religion. Okay, we cannot establish it. We can still teach religion, but we cannot establish it and put that on our students. We cannot force students to engage in religious exercises. It must be student-led. All right, and then lastly, this protects the free exercise of religion among citizens. Okay, so our citizens and our students in our school are able to lead their own religious activities. Okay, we just can't push it on them. All right, and now there's a big difference between teaching religion, all right, and forcing it on someone. When we teach religion, when it's in the Alabama course of study, we are bonded by a contract to teach our students about religion. Okay, but we're not forcing it upon them. So that's two different things. All right, and these are some of the main tips for educators when you're dealing with issues concerning religion in public schools. All right, so the first one is school-sponsored prayer is illegal and cannot be justified based on First Amendment prohibitions. Okay, school-sponsored Bible reading in public schools is an illegal activity. However, the Bible may be used as an instructional document to meet a secular purpose, like I was discussing earlier. Silent meditation or any other type of devotional activity sanctioned by schools will not be supported by the courts. Invocations at school-sponsored athletic activities violate the Establishment Clause of the First Amendment. And then this last tip I have is private voluntary prayer by a student is permissible under the Free Exercise Clause of the First Amendment. So once again, that goes back to the First Amendment and those protections that we have as teachers and students have as citizens as well.
Hi, my name is Davita Brown, and I will be recording on freedom of expression for students as well as search and seizure. Freedom of expression is derived from the First Amendment of the United States Constitution, and it states that Congress shall make no law abridging the freedom of speech or of the press or the right of the peoples to peacefully assemble. Now, one famous case was the Tinker versus Des Moines case, in which three public school students, wore black armbands to class in an effort to protest the government's policy in Vietnam. All three students were summarily suspended, and the students chose to file a lawsuit stating that they believed that their suspension was unconstitutional. This case became the leading case to address speech as a symbolic expression. And it was basically ruled that the peaceful wearing of armbands is an expression, is a form of expression that students are entitled to under the First Amendment. The U.S. Supreme Court actually held that it is unconstitutional to discipline students for the peaceful wearing of armbands or for other symbolic expressions of opinion unless it can be shown that material interferences with or substantial disruption of the school's routine did or would occur in such events. This case confirmed that students are entitled to all First Amendment guarantees unless the method or mode of expression creates material or substantial disruption in the school environment. So, freedom of expression for students, these rights may be restricted in the following scenarios. If there's evidence that the mode or expression is a disruption to the school day, the mode of expression violates school policy or rules by involving the destruction of property, or if it displays indecent or offensive images or language. Forms of student expression include protests and demonstrations. These are considered forms of free expression. Under certain conditions, students may participate in these activities. These activities must be peaceful, in line with school rules, must not result in damaging school property. These types of expressions may be heavily regulated by school systems in order to ensure the safety of students and to avoid chaos in the school environment. The next aspect of student expression is school-sponsored newspapers, which usually courts support that school publications are responsible for providing a forum for student expressions, yet it is the school's responsibility to finance this and also to ensure that students are practicing professional or responsible journalism. Non-school sponsored newspapers are newspapers that are not endorsed by the school and are printed outside of school at the expense of the students. Non-school newspapers are subject to restrictions regarding time and place, manner of distribution. Students don't have the right to distribute these papers. Students do have the right to distribute these papers as long as the distribution does not interfere with the normal school activities, or as long as the distribution and material don't create material disruption. Censorship. Limited review of school-sponsored publications may be permitted, but broad censorship is not. However, schools have the choice of determining if it will finance school-sponsored publications, but if the decision is made to do so, schools are subject to an open forum for student ideas, and broad censorship powers may not be imposed. However, forms of expression must not materially or substantially interfere with the proper order of the school. Next, we have dress and appearance. These forms of expression generally reflect student values, background, culture, and personality, and can be a sensitive issue. In fact, the U.S. Supreme Court has consistently declined to address this issue. Students' dress may be regulated if there is a defensible basis for doing so. However, regulations must be free from vagueness and ambiguity and must demonstrate a connection to the disruption. Regulations may not be based on fashion or taste as the sole criteria for regulation, and courts have upheld the following restrictions. School regulations necessary to protect the safety of students. Having long hair loose or down or wearing jewelry around dangerous equipment or labs could fall under this category. So students need to adhere to the rules to make sure that their physical bodies are actually safe. School regulations necessary to protect the health and safety of school. Maybe schools require students to keep their hair clean and free of parasites and germs, their clothing, their bodies. Rules prohibiting dress that does not meet standards of the community. This would be for students to dress in a manner that calls undue attention to one's body. And then finally, dress that results in material and substantial disruption to the orderly administration of the school. Wearing shirts that contain vulgar or offensive language based on race, color, gender, religion, or national origin. Finally, we have tips for administrators and educators. Schools may restrict freedom of expression where there's evidence of material and substantial disruption. Pamphlets, buttons, and insignia may be banned if the literal or figurative message is obscene, vulgar, or offensive based on an individual's race, origin, color, religion, or sex. Unsubstantiated fear and apprehension of disturbance are not sufficient grounds for restricting a student's freedom of speech or their freedom of expression. Students must be provided minimal due process before any punitive damages or actions are taken. Schools should develop clear policies to address these issues and communicate these policies to all stakeholders. Next, we have search and seizure, which is derived from the Fourth Amendment of the United States Constitution, and it states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause. Just as adults, students are protected by the Constitution and may enjoy many of the same constitutional rights. For students, this means that they are protected from unreasonable searches and seizures. Schools are tasked with balancing a student's individual rights to the Fourth Amendment, along with the duty to ensure a safe environment for all students. One famous case is New Jersey Vtlo, which was a landmark case that set the standard for reasonable searches in public school. Basically, a New Jersey high school teacher caught a student smoking a cigarette in the bathroom. A school official searched the student's purse and found rolling papers and cigarettes, and conducted a deeper search of the purse and turned up marijuana and drug paraphernalia such as pipe, plastic bags, a large amount of money, and writings that implicated the students in drug dealing. The High Court held that the Fourth Amendment does not require school officials to obtain a warrant or show probable cause before searching a student who is under their authority. Through this disciplinary action, the student attempted to suppress the evidence to say that it was an unlawful search because there was not a search warrant. However, it has been ruled that in some cases, many cases, especially in a public school, it's not reasonable for administrators to obtain a search warrant due to the time-sensitive nature of some of these offenses. Reasonable suspicion is something that is very important when it comes to search and seizure. School officials need only reasonable suspicion to initiate a search. Reasonable suspicion is based on information received from students or teachers that is considered reliable by school officials. Basically, reasonable suspicion is a must for school searches in order for it to be considered legal. If reasonable suspicion is established as the primary reason for a search, the search may be conducted by school officials. As long as the informant is known and not anonymous, and the information is deemed credible, courts will generally support administrative actions based on reasonable grounds. There are two aspects of reasonable suspicion that should be considered. The first, the search of a student requires reasonable grounds for suspecting the search will produce evidence that the student has violated specific laws or school rules. The scope of the search must be limited to the current incident and only limited to relevant students. The second, the scope of the search must be related to the objective of the search, the student's age and sex, as well as the nature of the infraction. So sweep searches of all students are absolutely illegal, and they must be specific to individual students and individual incidents. There are different types of searches. Student desks and student lockers. They're subject to searching if administration meets the standard of reasonableness. Both of these are considered school property, so it's not as much an invasion of privacy. However, as student lockers do offer some privacy, there is a greater likelihood that students might conceal items that are in violation of laws or school rules. And in the event that a student locker has to be searched or is searched, the student should be allowed to be present during that search. Strip searches should be avoided at all costs except in cases of health and safety. Only school personnel of the same gender should be involved, and the personnel should take care to ensure that the search is performed in the most dignified and private of manners. Backpacks. Searching student backpacks can be quite invasive, so stronger evidence to establish reasonable suspicion will likely be necessary. And vehicles. Vehicles may be searched as long as the standards of reasonable suspicion are met. Schools generally have clear policies in place on search procedures for vehicles that are located on school property, so students can be aware that those vehicles on school property are subject to reasonable searches for legitimate reasons, so that they don't walk into this blindly. Law enforcement of school searches. Warrants must be issued when law enforcement officials conduct school searches, because then it's no longer in the power of the school administrator. Drug and alcohol testing. Because of the rise in underage usage of drugs and alcohol, many schools implement drug testing programs and specify rules against their use in their policies. If such policies are in place, school administrators or their designees may give a breathalyzer test if they believe a student is under the influence of alcohol or drugs, even during school-sponsored events, as students under the influence pose a risk to everyone they are around. Many schools even build into their program, especially for student athletes, drug testing. So students are always aware of these. Schools just need to make sure that there is a clear written policy, clear of any vagueness or ambiguity. And canines. The use of canines in school has been a long debated issue. However, drug sniffing dogs are not viewed as a violation of students' Fourth Amendment right, as there is no expectation of privacy in the air around their person, which is what their intent is when they come into schools. So, final tips for administrators and educators as far as search and seizure is concerned. Administrators must ensure reasonable suspicion before performing a search. Searches must be based on a clear violation of a specific rule and must be specific to a particular incident and particular student. Clear policy should be in place to ensure that students are well aware and clearly understand their rights, the school rules, and the consequences for violating those rules. Thank you.
I'm going to move on to the next topic, which is due process. Okay? So a quick overview of due process. Due process in education means that fairness should be rendered in all areas, and that a teacher's or student's rights as individuals should be under no circumstances be violated. Due process is important because most court decisions regarding teachers, education, and ethical teachings pertain to the fundamental issues of fairness. All protections and rights pertaining to due process actually emerge from two amendments in the United States Constitution. So the first one is the Fifth Amendment, which states that no person shall be deprived of life, liberty, or property without due process of law. And the second one is the 14th Amendment, which asserts that the equal protection of the law should not be denied to any individual, nor shall any state deprive any person of life, liberty, property without the process of the law. Okay, so a quick overview of due process before we jump into this. Okay, so this is a legal requirements chart. Okay, and what I think this does is it provides educators with a lot of transparency on what they can do. So let's jump right in here. Tenured teachers. Okay, this is a hot topic when it comes to due process, tenure. Thankfully, Alabama is one of the states that does have tenure and protects their educators. So tenured teachers earns property rights to teaching positions. They earn continued service status. They may only be dismissed for statutory cause. Full due process procedures must be met. They are entitled to a formal and fair hearing if they are fired. Must receive prior notice of intent and grounds for purpose or proposed dismissal by registered or certified mail. Must be provided information regarding time, place of hearing with option of public or closed hearing. They have the right to legal counsel. They have the right to be provided names of witnesses. They must be provided transcripts of the hearing if requested, and they may appeal decision to higher authority or the courts if decision is not favorable. Okay, so that's some of the rights that tenured teachers have. Okay, now let's look at the non-tenured side. Contract may be non-renewed after it expires during the prohibitionary period with or without cause. That's 3 years for us in Alabama. They may or not be provided with reasons for non-renewal depending on the state statuses. Alabama is one of those states that does not have to provide a reason. They may or may not be provided with a hearing based on state statute. Written notice of non-renewal must be received on or before statute date required by law. Failure to meet the statutory date by the school board may result in continued employment by the teacher. Receives hearing if contract is canceled before contract date expires or if required by state law. Hearing not provided unless stipulated by state law. They do not have the right to appeal unless stipulated by state statute. And then the last one is may be provided hearing if there's evidence of a liberty right violation. Okay? Now moving into some tips for administrators and educators on this topic. The essential focus of due process is fundamental fairness. Okay, that's what we need to keep in mind as teachers. Okay, the essential focus is fundamental fairness. Okay, due process provides a remedy for students against arbitrary or capricious acts by school officials. The level of due process is a function of the seriousness or of the threat to deprive students of their liberty or property interests. Procedural or substantial due process singularity is of no value to school officials unless the requirements of both aspects are met when they are contemplating depriving students of liberty and property interest. Fairness is not always absolute. What constitutes fairness in one situation may be totally unfair in another. The courts use a balancing test to determine the appropriateness of the procedures that should apply in a given situation. Okay, so those are some handy tips when administrators or educators are dealing with due process. Okay, the next topic I will be discussing, and the last topic, is liability in student records. All right, so quick overview of student records, okay, because I feel like educators may get this mixed up sometime and need a refresher. All right, so educational records include records, files, documents, and then other materials that contain information directly related to another student and are maintained by an educational agency, institution, or person acting for an agency of institution. Okay, the records do not include instructional records or supervisory records. Okay. All right, student rights. Okay. I included this little picture right over here because I thought it was a nice little clip art to go along with this presentation. You see student rights and responsibilities, freedom of expression, policies and procedures, honesty and integrity, safety, accountability, privacy, accessibility, and equity and inclusion. I included a chart right here. It's the rights under FERPA, all right? And it breaks this down into 3 sections, okay? So it's the rights of students who are under 18 years old, the rights of parents, and then the rights of school personnel. So we'll go through those real quick. The rights of students that are under 18 years old, they have knowledge of types of records and locations of records and inspect confidentiality records. They challenge the accuracy of information contained on records. They have appropriate deletions or corrections executed. They request hearing to contest information on records thought to be inaccurate. Consent to disclose of personally identifiable information contained in files. Okay, now that's just some of the rights of students who are under 18. Now let's look at some rights of the parents that are protected under FERPA. They can inspect child's records if they are under the age of 18. They can challenge the accuracy of information contained on records. They have appropriate deletions or corrections executed. They can request hearing to contest information on records thought to be inaccurate, they can place a statement of disagreement regarding contested information remaining on the records. All right, now let's bump over to the rights of the school personnel. School personnel has access to confidential information for legitimate educational purposes. They can maintain personal notes on students for personal use. They can disclose educational records to comply with judicial orders for state and various federal agencies. They can disclose of disciplinary proceedings conducted against perpetrators of a crime, and they can also disclose of directory information on students as well. All right, now some handy tips when it comes for administration and educators on liability and student records are school districts and schools must have legally defensible policies and procedures consistent with the requirements of FERPA. Students, parents, and legal guardians should be informed of their rights under this act. Okay, so that they have to be consistent under FERPA. Accurate records should be maintained in the student's file indicating the name, title, date, description of educational interest, specific records examined, and the place of examination of student records for those who have access. Any corrections or adjustments to student records should be dated and initiated by the person responsible with the knowledge and approval of school officials. School personnel should avoid labeling children. When it becomes necessary to place disciplinary infraction information on student records, the information should be specific regarding the infraction committed, time, place, and witnesses as appropriate. The student should be present when such information is recorded. School personnel should refrain from aimlessness chatter involving third parties regarding confidentiality information found on student records. Gossip or careless talk among school personnel calculated to harm a student is not protected by qualified privilege. Okay, and that's some of the more beefy tips that I can give educators when they are dealing with liability and student records. Once again, my name is Austin Kilgore, and it was a pleasure to present this.
Hello, I am Dr. Kimberly Warfield, and I will be wrapping up our presentation with the last two sections, individuals with disabilities and the Alabama Educator Code of Ethics. So when it comes to individuals with disabilities, we feel that it's very important that everyone understands the law behind supporting individuals with disabilities. It is known as the IDEA. And it's a law that makes available a free and appropriate public education to all children with disabilities throughout the nation, and it ensures that special education and other related services are available to those students. In addition, IDEA governs how most of states and public agencies provide early intervention, special education services, and other related services to more than over 7.5 million students that are eligible, from infants, toddlers, children, as well as youth with disabilities. And last, one of the most important components is that it gives rights and protections to all students with disabilities. And as mentioned in the prior bullet, it covers them from birth through high school graduation or age 21, whichever one may come first. So parents as well as legal guardians also have specific rights under the IDEA law. Next, we will look at a few laws at a glance. So there are three major laws that we're going to look at briefly that protects the rights of people with disabilities. They're IDEA, Section 504, and the ADA Act. IDEA, as mentioned in the prior slide, is for students that have at least one of 13 qualifying categories of specific disabilities. These students also need specialized support and instruction to benefit from education. And this is the law that provides students with their IEPs or their individual education plans that are specialized according to their needs, as well as providing them accommodations and modifications that are outlined by the parent, school staff, administrators, as well as district personnel when they come together to put together the students' IEPs. The next one is Section 504, and this is an anti-discrimination law that protects all people that have a disability and impairs one or more major life activity, and learning is one of the key activities that is outlined in this law. It also prohibits discrimination in any program that receives any federal dollars, and also provides accommodations to remove any discriminatory barriers for individuals with disabilities. And the third one is the ADA, also known as the Americans with Disabilities Act. And this particular law is a civil rights law that protects discrimination, or prohibits, discrimination solely on the basis of disability in employment, public services, and accommodations. And it also protects any individual with a disability that has one of the following: has a physical or mental impairment that substantially limits one or more life activities, has a record of such impairment, or is regarded as having such an impairment. And overall, when we look at these three acts, the ADA, IDEA, and Section 504, all of them represent attempts to improve the living conditions of those with disabilities, as well as to ensure equal access and promote inclusion. So a few things to know as we wrap up this section when it comes to individuals with disabilities is that as educators, we must always keep in mind that people with disabilities are people too, and they should not be discriminated against regardless of their particular disability. Disabilities do not define who you are. And once again, as educators, this is something that we should always pour into our students, as well as teachers, faculty, and staff that are dealing with students with disabilities each day. And of course, we know that there are some disabilities that you can see and there are some that you cannot see. So we can't make any assumptions when it comes to students with disabilities. And differences make everyone unique. And that is one of the good parts of the disabilities, is that even though they may have a specific disability such as visual, hearing, learning, autism, physical, emotional, cognitive, or even when it comes to speech or language, they're different and they should be loved and treated fairly by everyone. And last, the last section of our presentation is covering the Alabama Educator Code of Ethics. So when we talk about ethics, society expects educators to model upstanding behavior that is not only moral, but ethical in nature. And ethics can be viewed as a philosophy of morality, as it deals with ought and ought not. And it is also both the moral and ethical foundation that guides the decisions an individual will make. And so when it comes to ethics, there are many states that have codes of ethics to further support and outline the desired expectations for their educators. And it is these codes of ethics that define the standard to which educators will guide their actions and decisions on a daily basis in the schools, districts, and classrooms. So one thing that I've noted after reviewing several code of ethics is that most of them have 4 basic principles. They're guided by conflict of interest, confidentiality, honesty, and responsibility. And these 4 principles are not in any particular rank and order, and definitely one principle is no more important than the other. But as you read several code of ethics, you will note that these are some recurring themes and principles that are noted throughout the code of ethics. So when we look at the Alabama Educator Code of Ethics, it serves as a guide for ethical conduct of educators in the state of Alabama. And as outlined in the code, it protects the health, the safety, welfare of students and educators. Additionally, it provides standards of conduct for educators as well as disciplinary actions. So not only does it give the guidelines, but what happens if an educator actually disrupts or commits an unethical act that is not substantial or not supported by those code of ethics, then what happens? Also in the Alabama Educator Code of Ethics, there are 9 standards with examples of ethical as well as unethical actions. So when it comes to the Alabama Educator Code of Ethics, it encourages fellow educators to report any unethical behaviors. It also it supports us as being familiar with local school board policies and chain of command for reporting any unethical behaviors. It also outlines that local superintendents have 10 days to report to the state superintendent their decision on any unethical behaviors or situation that they're currently investigating. And those decisions may consist of the following disciplinary actions. It may consist of a written reprimand, suspension, or revocation of certificates, or even the denial of a certificate. Next, these are also a few more grounds for dismissal as outlined by the Alabama Educator Code of Ethics. An order from a court of competent jurisdiction, violation of any laws or rules that are applicable to the educator profession, or any other good or sufficient cause would suffice an educator in the state of Alabama to be dismissed for a violation of any of the ethical standards. So next, real briefly, I'm going to play a video that is outlining an ethical dilemma, a situation with students. So we're going to listen to this short video clip of this ethical dilemma.
This short video represents how well-meaning interactions with students lead to blurred boundaries. As you watch, consider the guiding questions listed in the discussion post. After, post a short response and reply to a post or two from one of your fellow future teachers. Ms. K is a veteran teacher who is very popular with her students. She frequently offers students extra help after school, so it's not uncommon to see students visiting her classroom after school. She has tutored one of her students, Melissa, in a variety of subjects over a 2-year period. During that time, Ms. K has emailed and texted Melissa's cell phone using her personal email address. At first, these exchanges were very general, sometimes unrelated to schoolwork. For example, asking Melissa about a sick family member or how she was getting along with friends. Recently, the student began to text her teacher about more personal feelings. What do you think? How might you handle this situation? We want to hear from you. Use the questions in the discussion post to guide your response. This short video represents how well.
Now, after watching that short video clip, I want to ask you, what's your next step, or what would you do if you were the teacher in this particular situation that was facing an ethical dilemma with your student? That is the end of our presentation. We hope you enjoyed it, and if you have any questions, feel free to email us at any of the email addresses below. Thank you again for watching our presentation.